Hello, I'm Professor Robert Lenz, a law librarian at the University of Colorado Law School in Boulder, Colorado. This is the first of several presentations on secondary authority. This is the overview and framework presentation. In this presentation, I'll be introducing the idea of secondary authority and why it's useful and what it's used for. We'll also be looking at the various types of publications that are part of and considered to be secondary authority. From that, I'll provide a framework in how to approach those various publications depending on the kind of legal research situation you encounter. So what is secondary authority? Secondary authority, also sometimes called secondary law or secondary resources, are documents written by legal experts that help us understand and find the primary law. So it provides commentary on the primary law, and it gives us a contextual picture for how the primary law works, what are the key cases in an area or key statute, how courts have interpreted the statutes, what's the constitutional provision. It helps us understand what the primary law is. It can come in a variety of different forms. One is it can provide a broad overview of an area of law. This would just give you the general parameters of any particular subject area. What are those key cases, etc. On the other side, it can provide deep analysis into a particular subject area of law. You look at all the little nuances in the area of law and how that area of law may apply to particular fact situations, and it would look at all of the little details of the area of law. Secondary authority also helps us with the jargon in any particular subject area. Law often utilizes particularly technical language. That technical language has particular meanings. Secondary authority helps us understand what the meaning is for those technical terms, which can also help us develop search terms when we're looking to research the law. Of course, the other key reason we use secondary authority is to find citations to primary law. So within these secondary authority publications, you'll see citations to primary authority, but also you'll see citations to other secondary authority and help us develop a complete picture of an area of law through these various resources. So what are the uses for secondary authority? Well, the main use, particularly when we are new to an area of law, is to learn the area of law, learn an unfamiliar area of law. And this is understandable from the resources that are broad overview resources. You get an orientation to the key cases, statutes, the jargon of the law, and how it all works together. Of course, you can also use it when you need to have a comprehensive understanding of an area of law, or you're looking at nuances within a particular area of law. And you can use it too to find novel legal arguments, or to find insights into area law which isn't particularly obvious. It can also help us when we're practicing law. Some secondary authority is written for practitioners. It provides practical guidance and tips, checklists, and forms, so the practitioner can quickly come up to speed in a particular subject area and know how to proceed with either creating documents or doing filings, etc. So what are the publications that are considered secondary authority publications? The first group is legal encyclopedias. They're both national and state legal encyclopedias. The two key national encyclopedias are the American Jurisprudence, referred to as AmJur, and Corpus Juris Secundum, referred to as CJS. There's another class of secondary authority called American Law Report Annotations. Really, it's a publication called American Law Report Annotations. We'll be looking at these first two encyclopedias and ALRs in a later video. Restatements of the law. These are restatements of the common law subject areas. The drafters read through cases and identified black letter law, and then reprint the black letter law with the case citations. That is also a kind of secondary authority. Similarly, there's uniform acts and model laws, also drafted by legal experts for model or uniform acts for state law areas that state legislatures can then adopt. An example of this would be the Uniform Commercial Code. These are secondary authority until they're drafted by the state legislature, which time they become primary authority. Treatises, we'll look at treatises in a later lecture as well. Treatises are essentially books written by legal experts, and they can range broadly from multi-volume scholarly treatises to single-volume overviews such as nutshells. Of course, law journal articles, law review articles are a form of secondary authority, and really it's that we also want to understand the periodical indexes that help us find the articles themselves. And form books are also a kind of secondary authority publication. So from that long list of secondary authority publications, I think we can develop 4 distinctions within that long list. We can divide these publications by those that are descriptive versus those that are prescriptive, those that are scholarly versus those that are practical, those that provide the broad overview versus those that provide deep analysis into a subject area, and those whose coverage is national in scope versus those whose coverage is local in scope. So let's look at each of those 4 categories. Okay, the first distinction, the first way to approach secondary authority is descriptive versus prescriptive. When we say a secondary authority is descriptive, what we're saying is that it tells us what the law is. It's merely a description of what the law is in a particular area, what the case is, what's the statute, and how it's generally interpreted. At the other end is a prescriptive publication. And this kind of publication, what the author is telling us is how the law should develop. It's making recommendations or suggestions on what the law has gone wrong or what it's doing well or how it should develop into the next phase. So you'll find descriptive legal publications as legal encyclopedia articles or ALR annotations. Prescriptive publications typically are the law journal articles, and actually the uniform laws and model acts are prescriptive as well, as the commissioner there, the commission is determining, telling us what the perfect law for this subject area should look like. Okay, a second distinction is between secondary authority, which is scholarly, versus that which is practical. So scholarly, what we mean by that is the publication would be very deep, be comprehensive, it'd be authoritative. Typically this would be written by law faculty or practitioners who are experts in this area of law. And the goal of it is really to study all the nuance into a subject area and to understand it deeply and completely. The opposite view of that is a practical secondary authority publication. Really what we mean by practical is it's practitioner oriented. It's not likely to cover a subject area as deeply or as well as a scholarly publication. It's really designed to help the practitioner get an orientation to a subject area, what the key cases are, key statutes are typically within a particular jurisdiction, and provide guidance to practice law in that area. Treatises can be either scholarly or practical publications or other kinds of scholarly publications such as the restatements and law journal articles among them. A third distinction is that some secondary authority provides a broad overview while others provide deep analysis. This is somewhat similar to the scholarly versus practical distinction. But here for the broad overview, a publication that provides a broad overview may not really be practitioner focused. Think here in terms of nutshells or horn books or even study aids. The goal of those publications is to help you get an orientation to what the subject area is and help you figure it all out. Versus the deep analysis is typically scholarly publications where they provide that detailed coverage of a topic. So you can have a subject area such as criminal law. You can get a presentation of that in a single volume of a nutshell versus a 6 or 8 or 10 volume treatise from an expert in that area of law. And then finally, it's the coverage. Some secondary authority is written with national scope. They want to look at the law from all of the jurisdictions and help you understand how maybe the law varies across all these jurisdictions with citations to the primary authority. versus local, which is really the law in a particular jurisdiction. So here the distinction really would be between a national treatise on a subject such as criminal law versus a Colorado treatise on a subject such as criminal law. The Colorado treatise really focuses just on the law in Colorado itself. So now the question is how do we choose secondary authority? So we're familiar with the different kinds of secondary authority and the distinctions among them. Now from that framework of distinctions, how do we choose particular publications? Well, it depends on what we're trying to accomplish. If we simply want a general overview of an area of law, if we're approaching an area of law which we just don't know anything about it, we're just brand new to it, then typically you're going to want to go to the descriptive, broad overview publications. These would be nutshells or horn books, or particularly legal encyclopedia articles. Those can be extremely helpful to help us understand an area of law. If we're at the other end, we have some familiarity with the law already, but we need to understand a nuance in a particular area of law or a fairly narrow issue, then we're going to want to look for those comprehensive scholarly treatises. Those will help us sort through all of that complicated detail that might occur in that area of law. If we're doing comprehensive research on a fairly narrow issue of law, we'd like to know all the resources that are available to us for this particular issue and all the authority that cites that particular issue. You can go to American Law Report annotation. That's what it's designed to do. It's a very, very useful resource for helping us identify and understand issues of law. Or you can look at a law journal article. Typically those would be written to suss out all the implications of a particular issue of law. It's in a similar way if you're looking for developing issues in law or looking for novel legal arguments, perhaps to help you write a brief, or you're looking to write a law journal article yourself, want to build off someone else's work, you could look at a law journal article for that sort of thing. If you're looking for authoritative statements of the law that you want to cite in a memo or a brief, then you would typically look to the restatements. Those are always authoritative statements of black letter law. A law journal article from a peer-reviewed journal or top tier law school. These are typically written by the experts in the law and they're high quality journals. That would help you find an authoritative statement of the law. Or a respected treatise. Some treatises have an air about them. They've been around for generations and they are considered to be expert scholarly statements on the law. So that would be good for authoritative statement. If you're doing cross-jurisdictional research, statutory research, you could look at the Uniform Laws Annotated, or you could look at a 50-state survey as well. These are tools within Westlaw and Lexis. The ULA, the Uniform Laws Annotated, is part of Westlaw. That'll help you compare provisions of laws between different states and help you find cases for those states. If you're looking for practical advice, practicing law in a particular area, then that's the practice treatises. Those are great for finding checklists and other information on how to proceed for a particular area of law. Or a bar journal article. Those are particularly helpful too for understanding what the passage of a particular statute or case is in a particular jurisdiction. These are typically written by practitioners for other practitioners, and they're very, very good too. And if you're looking for forms to help you draft a contract or draft a will or draft a property agreement, then you can certainly do that from practice treatise in that subject area or for form books. So that's our broad overview of the framework for secondary authority. Before I leave this, though, I'd like to also look at the distinction between format. The two basic formats are print versus online. And there are pros and cons to using both of those. In print, I think what you'll find is that actually secondary authority, particularly the treatises, are a little easier to use in print. It's easier to obtain contextual clues from the publication itself. It's easier to skim an index or look at a table of contents or a table of laws. So that's good. The downside of it is they are not necessarily as up-to-date as a online publication, although that's not always true. It depends on how the publisher chooses to update the publication. For online format, you'll have more search options. Typically now, publishers provide the same search options as they do in print. In other words, you can get to an online index or an online table of contents. But of course, you can now keyword search the online publication itself. It's kind of a downside, though, is the online publication may not provide the same kinds of contextual clues that make it easier to understand the print material in the print publication. There are ways the publishers overcome this, but you just have to be aware of it. The updating presumably would be automatic. You don't have to update a print publication with a pocket part or whatever the methods are. But still, the online, you shouldn't assume that the updating occurs automatically. Typically, publishers will have a print publication and then the same online publication, they update them at the same time, which is to say once a year. So pointers one versus the other, it's availability. If you have a print publication in your office, you might use that certainly for starters, and then maybe go online to update cases or statutes or authority within it. The flip to it is you may have, as part of your online subscription, the treatise available online. You'll use it there. So the couple different things you can do. You can search online to find something within a print publication, then use the print if you have that same publication, or you can start with the print and update it online. And finally, a note about a general research method for secondary authority. I'll basically use the same with the exception of law journal articles. Typically, you'll develop a list of keywords, and then you'll use those keywords either to search the index for the publication, either in print or online, or of course online you can do a keyword search. You can also start in a topic outline or a table of contents within the publication itself, and that'll take you to the point in the publication where that area, the subject area, is discussed. Treatises in secondary authority typically have something called a table of laws, rules, or cases. This is very useful in that if you have a particular case name or statute that you want to understand, this table will tell you where within the publication that case or that statute is being discussed. So it's a quicker way in some ways than using an index to get to the commentary on that particular statute. Of course, once you find the cross-reference from the index or the outline, you follow that to find the volume and paragraph number within the print publication, or you link to the article itself. And then updating, these are updated only one of several different ways. If it's a hardbound publication, they are typically updated with a pocket part. So you'd look at the hardbound publication part of it first, and then you'd flip to the same section, the back of the volume where the pocket part update is, and do it that way. Sometimes that's a separate softbound supplement, but it works the same way. Some of these publications are loose leafs. In other words, are put into 3-ring or 6-ring binders, and pages are put in and taken out, and usually date stamped to let you know when it was last updated. And for online, the key thing there is just check the information bubble to see when it was last updated. Okay, so that's this introduction to secondary authority. Other videos will address specific secondary authority of publications. If you have any questions, however, please feel free to reach out to me. My contact information is on the slide. Thank you.